Good morning, everybody. We're going to move from the Department of Labor and the IRS to marijuana. So it's a little mellower topic, although maybe not for employers. So I'm sure that everybody's aware that there's a law that's not so new that became effective January 1st of 2014, but just to kind of borrow a phrase from the earlier presentation talking about a house without furniture, as you probably know, it's not effective yet. We're still, Illinois is still putting into place the pieces of the puzzle or the furniture. So while we have, the last that I saw, there were 2,300 medical marijuana patients who've applied for medical marijuana. Nobody can access it yet because they're still putting into place the cultivation centers and the applications and so forth. So this is something that's coming, but it's not in place yet. Okay, so as you say, it's called the Compassionate Use of Medical Cannabis Pilot Program. That's when it became effective. And as of now, there are 23 states, including plus the District of Columbia and Guam, that have medical marijuana programs. And so this has been going on for quite some time, and the purpose, of course, is to deal with folks who have serious disabilities, seriously ill individuals. And so there are legislative findings. When you look at the act, at least in Illinois, it's quite extensive, more extensive than you might think. And so the legislative findings find that the use of cannabis as medicine goes back for 5,000 years, and that it has both beneficial and therapeutic uses in treating and alleviating pain associated with certain illnesses, nausea associated with certain treatments for illnesses, and other symptoms with respect to a variety of debilitating conditions. And this is, interestingly enough, contrary to federal law, as you know, and federal law categorizes marijuana as a Class 1 control under the Controlled Substances Act that finds that there's no beneficial purposes for medical marijuana. So the legislative findings, again, go on to say that most of the arrests are made under state law, not federal law, and the states are not required to enforce federal law. So on the federal level, as I said, marijuana remains classified as a Schedule I substance under the Controlled Substances Act. While there are lobbyists trying to change that, that has not yet changed. And in October of 2009, the Obama administration sent a memorandum to federal prosecutors encouraging them not to prosecute people who distribute marijuana for medical purposes. So in those states where medical marijuana, where there is an act, in those 23 states, there's going to be no federal prosecution, and the states are also obviously not encouraged to prosecute. So how do people qualify? Well, the law doesn't ever use the word prescribe as it would with other types of medicine, but it allows physicians to recommend the therapeutic use of marijuana to people who are under the doctor's care, and there are 34 qualifying medical conditions for that, and that is constantly a moving target because they're going to be adding, and they have been lobbying to add additional medical conditions. And so qualifying patients have to get written certification. They can apply online, and for a status as a marijuana patient. And so just a list of the types of medical conditions that are included. And as you can see, some of them, most of them really are pretty severe. And so folks with HIV, AIDS, Alzheimer's disease, ALS or Lou Gehrig's disease, the list goes on. People who have had cancer treatment, people who have Crohn's disease, fibromyalgia, And, you know, again, the list goes on. So the purpose of it was to provide some kind of alleviation for those symptoms related to, again, pretty serious Parkinson's disease, pretty serious diseases. And this just kind of runs through, and, you know, materials have run through a list of those. Recently, the advisory board recommended 11 more health conditions be included in that, and some of those, for example, are osteoarthritis, people who suffer from that, people who suffer from migraine headaches, and people who suffer from post-traumatic stress syndrome. So not just generalized anxiety or depression, but somebody would have to have a doctor certify that it was actually post-traumatic stress syndrome. Certainly, you can imagine that folks that have been in the military might qualify for that. Okay, and then on July 20th, before then Governor Pat Quinn left, he signed legislation to add treatments of adults and treatment of adults and children with seizures to the act as well. And also, there are registrations effective this year. The act was also amended to provide identification cards for those under 18 who are dealing with any of these symptoms. Certainly, for example, children who have cancer can also apply for these cards. And obviously, that's not going to impact you as an employer, but just kind of giving you that additional information. And so the listed of medical conditions are severe and debilitating. And then just recently, earlier this month, there was a public hearing over at the State of Illinois building to review petitions for additional debilitating conditions that were to be considered. And so as of April 1, 19,500 citizens have logged on. But again, about 2,500 have actually submitted applications, and there are 1,600 approval letters. So what they're anticipating is that as these centers, you know, once this act actually takes place and people can actually get medical marijuana, they're expecting a surge, and they're actually hoping for a surge because, you know, to make it economically viable program. You mentioned, you know, the program is a pilot program, so each of the provisions in the program, unless it's extended, will expire January 1st of 2018. So now we have an act that was in effect January of 2014, yet it's still a year and a half later, and it's still not operational. Okay, so just to give you just a little bit of a sense, 3 administrative agencies are involved in working this out. There's the Illinois Department of Public Health, the Illinois Department of Finance and Professional Regulation, and the Illinois Department of Agriculture. And so the Illinois Department of Health is going to maintain a confidential registry for qualifying patients, and then caregivers. And so caregivers also can qualify because a patient may be in a situation where they're not able to actually physically go and get the marijuana, so their caregivers would also be eligible to have a card. They're going to distribute educational materials about the health risks. They will administer, adopt rules, and also with respect to food handling, because in addition to, most people think of marijuana as smoking marijuana, but there are edible products. Has anybody been to any of the states that have marijuana? Anybody ever gone to one of these places? No? Okay, so.
I actually can tell you that I was talking to a client who visited some friends in California, and they said that apparently there are now pop-up pharmacies. And when I say pop-up pharmacies, it is actually a screen, a touch screen. You push on it, you register, and over the touch screen, a doctor gives you a prescription and it prints out. That's what's happening in California. So.
Okay. Well, California is always an interesting state. So, so I went. My son lives in Portland, Oregon, which is fairly close to the state of Washington. And in Washington, like Colorado, it's not just medical marijuana, but it's just recreational marijuana. So, as research for this particular program, so we went there, and there's cookies, there's truffles, there's, other things. So, and they have it. It's just kind of a real weird experience to be there because they have on counters. Of course, there's a big security guard there at the beginning, and you've got to show that you're, I think it's over 21, 18 or 21. You have to show your ID when you go in, and then you can go in, and then they have descriptions because there are two different types of marijuana in terms of what they actually do. And so it's just kind of a whole very interesting experience, and that's what we're going to, wind up experiencing, here as well. And they only took, they didn't take credit cards, they only take cash or checks, which was kind of interesting. Okay, so the Illinois Department of Agriculture, there are cultivation centers. So there are, for example, Pharmacon LLC has applied and been given 4 shops and cultivation centers and dispensaries. There's going to be, for the state of Illinois, 22 cultivation centers. And so the registrations will be issued and renewed annually, and so that's and people are deciding where are these places going to be. So there's going to be places where the marijuana is grown, and then there's going to be places where the marijuana is sold. Okay, and those are the dispensing organizations. Okay, and then now, it's kind of interesting to see what happens. These are taxed, and so I know that Illinois has a lot of economic trouble, and maybe this is a way that Illinois can kind of make up that economic trouble, but this is any excess funds are going to be put into crime prevention programs. Okay, and so we'll get into a little bit of, of the legal part of it. So there are certain immunities and presumptions here. And so if you are a registered qualifying patient or a registered caregiver, then you're not subject to arrest or prosecution, and you can't be denied any right or privilege for the use of cannabis as long as it's in accordance with the Act, and we'll kind of get into what that is. And there's a rebuttable presumption that if you have registered, that you would be in, and you have the ID, that if you're using marijuana, that it's for a legal purpose. And if there's any conduct, and again, we'll kind of get into that is not related for treating or alleviating those symptoms, then that would be unlawful. Okay, and so before we just I'll kind of get into this and then go to a little bit of some other laws and other cases where medical marijuana has been around for quite some time, and then talk about, of course, as an employer, what your obligations are. So what the Act does not do is it is not okay, even if somebody was under the influence of medical marijuana. Again, we'll talk about whether you need to have people who are under the influence of marijuana working for you and how that's done. But if you're not allowed to work under the influence of marijuana. Okay, and so you can't have it in your vehicle, you can't smoke or use it while you're driving, you can't use it in a public place, you can't use it any place where you can't smoke cigarettes, you can't smoke marijuana. And so any private business is not prohibited from restricting or prohibiting medical use of marijuana on the property. And certainly when it comes to universities, colleges, or any other institution of post-secondary education, they are free to restrict the use of medical marijuana on their property. Okay, and so before we kind of get into just the legal discussion on the Act, just kind of a couple of cases that happened. So there's no law on this yet because the Act hasn't really, even though it's been enacted, it hasn't really gone into effect yet. So because nobody can get the medical marijuana yet in Illinois. And so one of the first cases that just dealt with medical marijuana went up to the United States Supreme Court and dealt with the question of, and it was in California, of all places, and so you had a couple of people who had medical marijuana for very severe disabilities that they had, and somehow they wound up getting raided by DEA agents. Went into their house, took all the marijuana, and got rid of it, and so there was a lawsuit over that. And the plaintiffs claimed that this marijuana was in California, And so and claimed that the DEA agents that went in and took this marijuana were violating the Commerce Clause, because the Commerce Clause requires that goods are in interstate commerce. It doesn't regulate goods that are just within the state. And so that they lost that argument. And that argument was lost because the court found that it's too difficult to be able to police whether marijuana is grown exclusively locally or whether it's in interstate commerce. And so there's a rational basis that because it's difficult to regulate that the federal agents, could come in and say, well, it's against federal law, and so, we can take your marijuana. So that was the decision. And so this is kind of, I'm just going to give you a couple more decisions elsewhere that show that whenever this issue's been litigated, the employer always wins, and the person who's taking the medical marijuana does not. So that's at least been the history of this so far. So another case that was in California, again the crazy California case, went up to the Supreme Court of California. And you had somebody who was fired when taking a pre-employment drug test revealed that they had marijuana use. And they said, how many people here have any drug testing? Okay. And so of those that have drug testing, how many are pre-employment drug testing? Okay. How many have random drug testing? Okay. And then post-accident? Okay. So, because the question comes up, how would you know whether I am using medical marijuana unless I tell you? I go to Human Resources and say I need to be reasonably accommodated. The only other way you would really know is if you get drug tested, right? So if I work for an employer that does no drug testing, unless I need some kind of reasonable accommodation with that and talk about it, presumably nobody's going to know about that. But if you have drug testing, that's where you'd find out. So in this particular case, this person was fired, was given a conditional offer.
I was worried that this was going to happen. I saw it flashing, and I tried to call.
Oh, okay.
See if it just turns back on for us. Huh?
No.
Maybe.
All right. Well,
I've got it.
I can
Who
still.
needs the IT man when you got me? That's it.
Very good. Good job. Okay, and so here you had an employee who was given a conditional offer of employment after you passed the drug test, and he did not pass the drug test and said that the employer then violated the California Fair Employment and Housing Act by discharging him and failing to reasonably accommodate, and this is the argument that would be made, reasonably accommodating his disability. And the court said no, that the FEHA does not require employers to accommodate the use of illegal drugs, and that the Cannabis Act doesn't require employers to accommodate employee marijuana use, and there's no public policy wrongful discharge. So that's in California. California said no, employers can have those types of rules that say no medical marijuana. And then even in Colorado, again, a state now that has beyond medical marijuana, an employee was terminated for testing positive in violation of an employer had a zero tolerance policy. And he was then denied unemployment compensation benefits because of the unlawful activity. And the court there held that the benefits were properly denied, and that the authorization to use medical marijuana is not equivalent to a prescription that we would get for other types of drugs. So I just wanted to give you a little bit of a history and there are other cases as well, that when this issue has been litigated, it has not been in favor of folks who are taking the medical marijuana in the employment area. So now moving to the Illinois Act. So the Illinois Act, as I say, is lengthier than you would think, and it states that no employer can penalize a person, this is a little typo there, solely because of his or her status. As a qualifying patient, so it protects, supposed to protect both the patient and the registered caregiver, unless failing to do so would put the employer in violation of federal law, or cause it to lose any money or licensing benefits under federal law. Okay, and then there's another provision that says that for purposes of medical care, a patient's authorized use of cannabis is to be treated like any other medication. So again, this particular provision isn't dealing with employers. It's saying if you have to go to the hospital for something and you are a user of medical marijuana, that you can't be refused any treatment. You can't be discriminated against because you're using the medical marijuana. Now, when we get to Section 50 of the Act, that deals with employment, okay? And that's says that nothing shall prohibit any employer from adapting reasonable regulations concerning anything related to the marijuana. And also, nothing shall prohibit an employer from enforcing drug testing, a zero-tolerance policy, or a drug-free workplace, as long as it is applied in a non-discriminatory manner. So, if there are drugs that are considered to be unlawful under federal law, in addition to marijuana, you wouldn't be able to give a pass to somebody who tests, and I don't know that anybody would, but you wouldn't be able to give a pass to somebody who tested positive for example, cocaine, and not for medical marijuana. You can't distinguish somebody who's taking medical marijuana. So there's nothing in the Act that limits us as employers from disciplining somebody who violates a workplace drug policy. Nothing in the Act limits an employer's policy to discipline or otherwise terminate somebody who failed a drug test. Nothing in the Act can be construed as a defense for a third party. So who would a third party be? A third party could be an independent contractor. A third party can be somebody, because there are some employers that are required, anybody who's working for that employer needs to be drug tested because they have certain drug testing requirements. Okay, and then if somebody is viewed as they're working is deemed to be impaired, that person, of course, is not protected, even if they are a registered qualifying patient. So if you see somebody on the job, just as you would if you thought somebody was under the influence of alcohol, or if you thought somebody was under the influence of something, you don't know when somebody's acting impaired what they're under the influence, they are not protected then under the Act. Okay, if those in manufacturing, if there's any kind of disregard for that person's safety or others, if they're involved in an accident that results in any kind of damage, then they're not protected. And any employer who decides that they're going to discipline somebody who is a qualifying patient, because the employer has a good faith basis that the person appears impaired, then just needs to allow the employee an opportunity to contest the basis of that determination. Okay, again, more protections for employer under the Act. And so nothing in the Act creates a claim against an employer if the employer has a good faith belief that a registered qualifying patient used or had marijuana while on the employer's premises or during the hours of employment. If the employer has a good faith belief that the person was impaired by working, the fact that the person is a registered qualifying agent is not going to protect that person. And if there's any injury or loss to a third party, if the employer didn't know or had no reason to know that the person was impaired, then the Act protects them and the employer would not be liable. So now we have, a situation that's kind of odd, where we have federal law that says that there's no accepted medical use for marijuana. Again, that federal law was passed back in 1972. And so now we have in 2014, when this act was passed and some of these acts later, states are saying, well, we think that there is an accepted medical use. And again, we're limiting to folks who have pretty severe disabilities, injuries. So, and then you have the Americans with Disabilities Act, which is a federal law, which doesn't allow current illegal drug use from coverage. And in fact, under federal law, marijuana is an unlawful drug use. So, as I stated earlier, even though there have been legal challenges in other states, no state has been found to require employers to accommodate medical cannabis use. So what do you do? What do you do? So I think it depends on an employer, what your philosophy is. And so if an employer's philosophy is there's absolutely no tolerance, zero tolerance for drug, particularly, if you're in the manufacturing, then that's what your policy is. And I think you're going to be, I think that Illinois, once it's litigated, and there will be litigation because there always is, right? So somebody will challenge that. And so I think that given the way the Illinois law is drafted, that if you have drug testing policies and your drug testing policy says, I'm not distinguishing whether you're a cannabis user that has approval under the Act or whether you're just smoking marijuana for recreational purposes, I'm saying that anybody who tests positive for marijuana is not working here, then I think that would be upheld, that is part of it. For employers without drug testing policies, you have kind of a choice as to how you want to handle it. As I said earlier, how are you going to know if you don't have a drug testing policy whether somebody is using it? One of the things about marijuana that's different than, for example, cocaine, is that marijuana stays in your system for much longer in terms of being tested. So if you're a habitual user of marijuana, let's say there's somebody who has Crohn's disease and uses marijuana whenever that develops pain, and then gets tested, there's no indication, that test doesn't say whether that person is under the influence of marijuana at that time. It just tells you that there has been marijuana in their system within a period of time. The more habitual user, the longer the marijuana is going to stay in the system. So somebody who, for example, uses marijuana on a daily basis, you're going to have that in your system for 30 days, up to 30 days. If it's somebody who's a much more sporadic user, then it'll be less. But it's a little bit different than somebody, for example, who tests positive for cocaine, which runs through your system much more quickly. You can feel more confident if they're testing positive for cocaine that they're under the influence while they're working for you. Someone who uses marijuana is not necessarily. So I think it is more of a philosophy that an employer has to decide. Obviously, we're dealing with people who have very severe disabilities that can be chronic. You have somebody, for example, who's undergoing chemotherapy because they've been diagnosed with cancer, and now I'm sure everybody knows somebody who's been through that. There's terrible side effects on that. There's a loss of appetite. And so the medical marijuana, that's somebody who would be able to get medical marijuana to help alleviate those symptoms, to increase their appetite. And so is that somebody that you want to fire? Is that somebody that you want to, or not? And so again, that's a decision that employers need to make. So, do you need to revise or add new policies? I'd say in general, there's not really a need to add new policies. Those that have drug testing have those policies already, and so those policies state that unless you wanted to make, there was a sense to make a change on that and make an exception for those who have medical, approval for medical marijuana. You could add statement, and here's just an example, to any existing substance abuse policy that says that this doesn't extend to the right to report to work under the influence of medical marijuana, and kind of track the language of the Act, and that to the extent that you're subject to any drug testing, you'll be required, you'll be affected as anybody else who was that. So again, it depends on what your philosophy is. If your philosophy is, I don't care that it's medical marijuana, we just don't accept anybody who is smoking marijuana, then you have the consequences of that in terms of perhaps losing good people who are using medical marijuana. But I think you're allowed to do that. Another policy that you could have is while individuals may lawfully use marijuana as prescribed, individual employees are prohibited from using or possessing marijuana on company premises or being impaired by marijuana while working. Again, that's for a company that decided that when it comes to medical marijuana, if there's somebody that has has been approved for that, It's supposed to be, and this is why I was a little bit surprised to hear about your push the button, it is supposed to be a doctor who you have and it's defined in the Act as not just going to the doctor that you know who prescribes medical marijuana, but a doctor that you're supposed to have a long-term relationship with.
Jody, just a question, and I
Sure.
don't know if it would be to the benefit of everybody else, but I'm curious. You did say that, if you wanted to put some type of policy in place regarding the use of medicinal, that it's not allowed on premises, you can't be prepared, but you're almost acknowledging that you may have employees with medicinal purposes. Do you potentially, are there any steps that need to be taken to make sure that you don't find yourself in some type of wrongful termination or discrimination allegation from an employee who's not medically cleared or medically certified for use, but post-accident gets drug tested and has it in their system? If you have a policy or a procedure in your organization that people that are medically allowed to use, as long as they're not impaired on the job, you had even said it, and we talked about it
Right.
before, it's in your system for a long time. So what if an employee that is not medically approved gets hurt, goes for a post-accident drug test, and is found to have it in their system and gets terminated?
I would think you'd be fine with that. I would think you'd be fine, because the protection there is for people who are prescribed. So just because recreational marijuana use is not here in Illinois, and so it's just for those who are prescribed. So if you wind up, you could make a distinction between somebody tests positive. Again, this is depending on the employer as to whether you want to do it, because I think if you want to take a hard line and say, we're just not accepting it, that's it, you test positive, I think, legally you can do that. If you wanted to take a softer line and say, I'm going to treat people who have medical marijuana, who've been approved for medical marijuana and can show that they're certified, and I'm going to make an exception for that, I think you can make an exception for that, and that does not open the door to every recreational marijuana user that you may have. Then again, also, if somebody's gotten into an accident and test positive, I think that's something that you need to explore with them. Yes.
So I guess my question or my concern would be a big picture, taking a look at it. If you say, okay, it's all right to use medical marijuana, just you can't be inebriated or under the influence while you're on the job.
Right.
That person, someone that is cleared to use medical marijuana, then has an accident. Obviously, they're going to go for a drug test. It's going to come back positive. How do you determine as an employer whether or not they were under the influence at the time, and how, if you, for some reason, had cause or had reason to believe that they were under the influence, how do you handle that on a case-by-case basis, and there's no risk of discrimination if it happens again with someone else and you get a different outcome? So, for example, you suspected both were under the influence. One of them, you might have had a witness that said they were driving erratically, and you terminate that person regardless of your policy. The other person you don't terminate. How do you prevent a wrongful termination suit in a situation like that if you don't have a zero-tolerance policy?
Yeah, so I think it is, part of it is a case-by-case basis, and so I think it's taking into consideration all of the information that you have. I think what you would do is you would conduct an investigation, and you would try to determine, whether there were any witnesses. For example, somebody's driving a forklift, how did that accident happen? You would investigate like you did any accident, and then you would interview the employee, try to find out, the information. I'm not sure if when you spoke to the MRO, when you got the drug test back from the medical officer, whether there's any way to determine a level like there is with alcohol. So with alcohol, there's a way to,
And there's ways to.
And I think that's the problem. I think with the marijuana, there isn't. You would just test, you would just test positive, and I think that
if they do a blood test, I know they can actually check for THC levels in the blood. But I also know that the relevant THC level in the blood doesn't necessarily mean you're impaired at a particular time. Due to chronic use, things of that nature, it can fluctuate from individual to individual.
Yeah, it's a difficult question there, and so I think that's, those are the kind of questions that'll probably be, be litigated, because somebody who is fired as a result of that would say, I wasn't, it was 3 days ago when I had, an attack or an episode or something like that, and that's not what happened. But I think you would have to research in terms of the accident,
and that's
and
my
then make a
concern,
determination.
exactly.
And I think you're protected in that under the Act, though. I
Okay.
think you're protected because the Act says if you are acting in good faith, if you have a reasonable basis for it,
Okay.
and you think that that person was under the influence because of the investigation that you conducted, and it showed that the person was driving erratically, if it was a forklift or whatever it was, then I think you have a reasonable basis, and then I think you're going to be protected.
Okay.
So I think it's the balance here, and so we have as an employer, we have to keep a safe and productive workplace, and so we have that balance that's important, and then also, versus our obligation, or whether it's your philosophy or ethically or however you want to accommodate when reasonable, somebody who's got a disability where the use of medical marijuana is allowed. And so I think what the Illinois legislature has tried to do here is really try to protect employers. I think, there's probably a big lobby on that, trying to protect employers, because other acts in other states don't even mention employers. They're really dealing with the ability of a person to get medical marijuana for their particular ailment, their disability, and doesn't really address it in the workplace. And so in those particular states, there is no protection in the workplace, for somebody who winds up getting terminated as a result. And I think, Illinois does mention employers in the Act, but has loads of protection for employers. And so even if you are a more, I'll just use the word benevolent, right, in employer, and said, I am going to make some exceptions. I know that there are certain people in my workforce that have some of these, disabilities, and if marijuana is something that would help them, then I'm going to have an exception for that, so long as they have the certification. But you are protected. The Act clearly says that if somebody appears as if they're under the influence, if somebody has an accident, you have a reasonable basis for that, then you can take action on that, and that you are protected. Okay, so we kind of covered, does an employer have to excuse a positive drug test based on medical marijuana? No, I don't think you do. And so it's because we're not discriminating against the employee for use of medical marijuana. It's anybody who's got any illegal drug. But could you, if the employer's philosophy was that we wanted to take that into consideration? Yes, you could. And so again, we have, again, interesting ways that this will come up, although I think based on the history of other cases, how it's been resolved, I think the Illinois Supreme Court would be in accordance with this, even though the Illinois Human Rights Act has a requirement to accommodate disabilities. The question would become, do we need to have, when it comes to disability law, and again, not under the Americans with Disabilities Act, because it's not, that's a federal law, and marijuana is only allowed on state law, but under the Illinois Human Rights Act, if somebody has a disability, an employer has a requirement where we have to have an interactive dialogue as to how can we accommodate that disability. So I can see a lawsuit or, a charge with the Illinois Department of Human Rights coming up saying, there should have been some kind of an accommodation to me. That is my disability, and as part of my disability, I have take medical marijuana, and I was terminated. So we'll see how it goes. But as I say, I think employers are protected here. Okay, and so just parting thoughts. Somebody's going to be the test case in Illinois. And nobody here wants to be that test case, just because it's expensive. You're going to have a lot of people lobbying. I think the question is, do you have positions that are safety sensitive? To me, there's a difference between somebody who's an administrative assistant and somebody who is dealing with heavy machinery. And so that's and sometimes employers distinguish their drug testing based on the positions that are being held. And then, again, who's going to be the test case in Illinois to be able to resolve this? So as an employer, you want to think about what do you want to do, what's going to pose the least risk given your particular workplace. Zero tolerance is certainly defensible, but it's certainly not empathetic when it comes to those folks that are in our workplace that have these severe disabilities, and sometimes the other medications that they take have really bad side effects, and so that they find that medical marijuana is something that assists with them. And really, the focus is, as it should always be, whether we're dealing with alcohol, whether we're dealing with marijuana, whether we're dealing with really anything, is that person doing his or her job effectively? Okay, any other questions? Okay, in the back of my packet, there's a joint for everybody here.